I'm Jennifer Bradbury. I'm a solicitor at Irwin Mitchell Solicitors. I predominantly work in managing professional deputyships on the financial side. And obviously I've worked at Irwin Mitchell for a few years. I'm just going to... So this is roughly what I'm going to cover, obviously an introduction to Irwin Mitchell and what we do. I am going to go over capacity as well. It will touch on some of the areas obviously talked about earlier. And then lasting powers of attorney and deputyship and the Court of Protection. So Irwin Mitchell is a national law firm founded in 1912. We are a really big firm with offices throughout the country. We've got a specialist court of protection department dealing with attorneyships, deputyships, and also damage management through trusts. We are currently acting or in the process of appointment for 1,250 financial deputyships. And that is the biggest firm in the country dealing with those financial deputyships. We do also have a specialist public law department, and so we separate out the issues to do with health and welfare matters, public funding and care placement issues, and also education. We also have tax, trust and estates department, obviously dealing with a wide range of issues, including wills. They also deal with the actual lasting power of attorney, so actually putting them in place. Estate administration and tax planning and compliance issues. So obviously capacity, the main legislation is the Mental Capacity Act 2005, which was obviously talked about earlier. And obviously the Court of Protection and deputyships is the side of things once somebody lacks capacity. So the Mental Capacity Act covers England and Wales and came into effect in 2007. It establishes a single and comprehensive legal framework for decision making for people over the age of 16 who may not be able to make their own decisions due to illness, learning disability or mental health problems. And it does include the effects of drugs, alcohol or temporary loss of capacity as well. So it's very wide ranging in scope and obviously dealing with personal welfare decisions, property and general affairs of a person, and essentially covers any decision which a person cannot make for him or herself. So the general principles of the Mental Capacity Act, there's a presumption that a person has mental capacity unless proved otherwise. And obviously this was talked a little bit about earlier, that we need to look at a person's capacity, and we are always presuming that they can make decisions rather than cannot. A person should have all practical steps taken to help them come to their own decision without success before they're treated as being incapable. The third principle is that there's not to be a presumption of lack of mental capacity just because a person makes an unwise decision. So something that we might not do, we've got to not presume that because it doesn't look sensible that it means somebody lacks capacity. So the fourth principle is that any acts done for a person lacking mental capacity should be done in their best interests. And also the last principle being that before taking an act for a person lacking mental capacity, consideration should be given as to whether the desired outcome can be achieved in a less restrictive way. So we're always looking at the least restrictive way of helping somebody, whether that's with their finances or otherwise. So it may be situations where we will have overarching authority to manage somebody's finances, but we put in place situations where they can manage part of their finances and we help with larger decisions. So it's always looking at how are we enabling them to have freedom and take action in their own lives and not restrict them at all. So looking at what's meant by lack of capacity, under Section 2 of the Act, a person is unable to make a decision for themselves if at the material time they are unable to make a decision for themselves in relation to the matter because of an impairment of or a disturbance in the function of the mind or brain. Obviously, this is a notion that capacity is decision specific, so we've got to look at the material time, and that's really important in considering whether somebody lacks capacity. And as part of my day-to-day job, it's something I am considering all of the time. When my clients come to me, and it will be in the financial context because of what I do, I am always assessing whether at that time they're able to make the decision for themselves about the thing they're bringing to me. It may be that they would like to purchase something, or that's usually the situation in which I'm working. And we're always looking at the time when the decision is to be made. Are they able to make that decision for themselves? So when is a person unable to make a decision for themselves? So under Section 3 of the Mental Capacity Act, a person is unable to make a decision for themselves if they are unable to understand the information relevant to the decision, to retain that information, to use or weigh that information as part of the decision-making process, or to communicate their decision. And that's whether by talking, using sign language, or other means. And so it's if any element here is missing. So if somebody can understand the information, but they can't retain that information for long enough, or if they can't weigh up that information as part of the decision making, then they will be unable to make the decision for themselves. And importantly, the communicating their decision, we do have to look at how we communicate with people, whether that's facilitating using communication aids or using simple language. We can't just assume because somebody can't communicate that they lack capacity. Quite often, if you're able to bring out information and decision-making information by communicating with somebody really well and tailored to them. So looking at the other considerations, I mentioned earlier just that it's decision specific. So this this was a case in which a lady was it concerned the capacity of a married woman to decide whether or not she was going to live with somebody, the husband, and the husband was actually in prison for some serious offences when the marriage was taking place. The lady had learning disabilities, and the decision was really important that it's decision specific and not sort of specific to the situation. So looking at other considerations, obviously unwise decisions. The decisions this lady had taken appeared to be unwise, and that didn't necessarily mean she lacked capacity to make the decisions. Quite often when we're looking at capacity, we do need evidence from a suitably qualified practitioner. It's not always the case. As you heard earlier, everybody who works in this field needs to understand how capacity works and what considerations there are. But quite often, if it's a complex condition, then evidence from somebody who is qualified is advisable. So when we're looking at somebody who lacks capacity, Section 4 of the Act sets out a framework for considering what's in somebody's best interests. So as far as possible, the decision maker needs to consider the person's past and present wishes and feelings, including any written statements that they made when they had capacity. Also considering their beliefs and values that they would likely to have had if they had capacity, and factors that would consider if they were able to do so. And also it's really important that other people should be consulted where appropriate. And now that's obviously not just people who are appointed, so Court of Protection deputies and attorneys, but family members. Essentially the Act is is very key in making that important. It's not actually a status situation whereby just somebody with authority has to be considered. It is all to do with who is interested in this person's affairs and who should be consulted, essentially. So we would say that your status as an attorney doesn't secure or it shouldn't secure your consultation, essentially. If the people involved are doing the right thing, they should be consulting you anyway. So turning to the Court of Protection, the court protects vulnerable people where they lack capacity to make decisions for themselves. And it is divided into the two sections, obviously property and affairs and health and welfare, considering medical treatment, residency and care and other things. So the court can make one-off decisions, including declarations and orders, or it can appoint a deputy where a series of ongoing decisions are required. Now, obviously, the Court of Protection is for making decisions about people who lack capacity. Obviously, this talk is about, or I've been asked to speak about lasting powers of attorney. It's really important to appreciate the situation in which a lasting power of attorney could be useful, because if one cannot be obtained, then the Court of Protection is the only option. So I'll go on to talk about lasting powers of attorney. So a lasting power of attorney is a legal document, obviously, which appoints an attorney to act on a person's behalf. Now, the donor of the lasting power of attorney must have capacity to make the lasting power of attorney. Now, this is not the same as having the capacity to manage your finances. So it's slightly different to that. So what it means is somebody must understand the decisions that they need to make. They need to understand why they need to make those decisions, and they need to have the understanding of the relevant information relevant to the decisions they're making, and what is the likely consequences when they've made the LPA. So it doesn't mean somebody, for example, has got the ability to manage all their own finances, manage investments, everything like that. They just need the ability to understand the power they are giving to somebody else. So that is the difference. And that can be quite important, actually, because some people can assume that if you're not able to deal with your finances, then you cannot give the power to somebody else. And that's not the case. Obviously, you do need to look at who can determine that situation, that you have capacity. And I'll talk a little bit about that later. So the two types of lasting power of attorney are the property and finance. This is for decisions about, obviously, general finances, for example, collecting benefits, dealing with bank accounts, running someone's day-to-day finances, and it can include things like buying and selling properties and obviously dealing with investments. The second type of lasting power of attorney is the health and welfare, for decisions about where somebody should live, what care and medical treatment that person should receive, and day-to-day decisions about things like eating and obviously what somebody wears. The important thing to note about lasting powers of attorney are that they take effect as soon as they are registered with the Office of the Public Guardian, and they can only be revoked if the donor still has capacity. So prior to lasting powers of attorney being in place, there was a different system which didn't require registration in quite the same way. What you can do is obviously make a power of attorney, but unless you register it, you cannot use it. And if you haven't registered it and there's something wrong with it, and the person has lost capacity since then, you're then stuck in a situation where you would need to involve the Court of Protection. So to make a lasting power of attorney, you must be 18 years old. And there is an important difference between the two types. And Tony had mentioned this earlier, that the property and finance, it can be used when the person has capacity, if that's actually set out in the power itself. And then it can also continue to be used when the person lacks capacity. Whereas the health and welfare LPA can only be used by the authorised person if they no longer have mental capacity. So what this means, especially for the health and welfare side of things, is that you may have a power and you may believe that you can use that, but as the attorney, you must always be looking at can the donor make those decisions themselves, and if they can, then you don't have any authority to use the power. So this is where people can sort of run into trouble, where they believe the power just works as it is, and that isn't the case. With the property and finance, obviously, if you set out in the power of attorney that it can be used when somebody has capacity, that can then be done, and that's a sort of practical aspect, really, that if somebody, for example, has difficulty in going to the bank or communicating with people at the bank, then the attorney can step in, even though that person still has capacity to sort of do the things themselves. So it's quite useful in that way. So lasting powers of attorney, the sort of practicalities of it, there are very specific forms to be completed, and these set out the scope of the power. Obviously, you set out the who the attorneys are, and one of the elements of that is deciding whether the power should be joint or joint and several. Now, joint power means that an attorney has to act together in every decision, and joint and several means that the attorneys can act separately and independently. And so you have to think very carefully about which choice you make. A joint power can be really useful, but it can be inflexible if, for example, the two attorneys don't live in the same place. It could mean delays where you're having to seek the approval of both attorneys to get things done. Some people choose to set out joint powers for big decisions. So, for example, selling a house, a joint decision, whereas other matters, joint and several, so that things can be dealt with sort of quickly and practically. So the extent of the authority within the power, there are lots of options to set out what you would like to include and not include, essentially. There's a section in which you have to set out instructions for the attorneys in the future, and it's quite important to word that carefully. So I should say, lasting powers of attorney, there is lots of guidance online to do them. They are drafted in a way that anybody should be able to do them without legal advice, but we would always say it's quite important at certain points to get advice, because what you want to make sure is that the power is going to do what you think it's going to do in the future. And so it is useful to get advice to make sure that you are wording it in a way that's going to work in the future, essentially. So the other things you need to decide are whether you would be notifying anybody of the registration and also replacement attorneys. So if you don't include a replacement attorney, if the attorney that you appoint stops acting, if they pass away or if they lose capacity themselves, then you have a situation in which you may need to go to the Court of Protection to have somebody acting in the future. Whereas if you've got a replacement, obviously you've provided for that within the power itself. So I will just now touch on the certificate provider part of the power of attorney, because this is something that people do get a little bit confused with. So the power of attorney you have to have a certificate of capacity essentially completed by an independent third party at the time that the lasting power of attorney is signed. So this person is referred to as a certificate provider. Now people think that must be must have to be a doctor, and that's not actually the case. It needs to be a person that's over 18. They can't be related to the person making the power of attorney, and or any of the people being authorised in the document. And they do need to have known the person for over 2 years. So it can be a friend or a neighbour. It is often carried out by professionals, though, such as doctors or solicitors. If it is carried out by a doctor or a solicitor, they don't actually need to know the person for 2 years. But if it is being done by a friend or a neighbour, it does have to be somebody that knows the person very well. And I would say in a complex situation, the best situation is to actually have a medical professional to act as a certificate provider, particularly where you've got a complex health condition involved. That way, there isn't any question. There couldn't be any question later on if anybody else later raises that this person did not have capacity at the time of making the power. So that's quite important. So just a few other things. Obviously, the power needs to be registered with the Office of the Public Guardian before it can be used. There is a registration fee at £82, and this sometimes puts people off taking that next step. It can take up to 3 months for the Office of the Public Guardian to register the power. And so really, once the document is drawn up, it should be registered as soon as possible. We would say that specifically because the Office of the Public Guardian does check the validity of the document, and if they do find anything wrong with it, it would come back to you. And if the person's capacity has changed, if somebody's lost capacity since then you will have an issue. That's particularly the case in a situation where somebody's capacity may be deteriorating. So potentially situations like Alzheimer's, that kind of thing, you need to make sure that you get the power put in place while the person's still got capacity and things haven't changed. That is obviously different in a situation where you've got learning difficulties or things like brain injuries. So once registered, the attorney does not have to take over immediately, and they can use the powers intermittently if instructed to. So essentially, the document itself does set out the scope and how the document is to be used. So it is quite flexible, but that wording has to be it has to be good, so that in the future you don't have issues with its use. So I will just say a thing about the order of the signing of the document as well. So essentially, the donor must sign everything first, and then the certificate provider, and then the attorneys sign. And that structure is set to make sure that the donor has understood everything, obviously, and then the certificate provider is confirming at the same time that that's the case, and then the attorney signs. And it is usually practical and best practice to get everything signed at the same time, and then there cannot be any sort of suggestion that capacity has changed in the intervening periods. So just also a brief note about the certificate provider. They are providing a really important role, and that's why it's really important to think about who actually will do that role. So they are confirming that the donor understands the purpose of the power and the scope of the authority that they're giving out. They're also confirming that there hasn't been any fraud or undue pressure on the person to make the power of attorney, and also that there's nothing else that would prevent the power from being put in place. And so if you're asked to do that role, obviously it's important to think about whether that's something that you can do. So what I would say here is that sometimes people are tempted to try and make a power of attorney in a situation where it's not appropriate, because obviously there isn't a requirement for a professional to be involved in this part of it. But what I would say is that there can be difficulties later on if it's felt that that information wasn't correct at the time, and that the certificate provider was not providing, a true confirmation of what the situation was. So there isn't any point in trying to make a power of attorney where, for example, somebody does not understand. It will come out later on, essentially. Yep. Yes. There is a section of the form in which, if somebody cannot sign, there is a provision for that situation. So yeah, it just a physical inability to sign doesn't prevent them making a power at all. It's a little bit like the situation in which communication is difficult. There has to be ways and means of facilitating that in the documents. Yep, it's not a role that's ongoing, no. But obviously, if it comes to light later that the certificate provider shouldn't have provided that, that confirmation, the power can be revoked. You could be investigated by the Office of the Public Guardian, and obviously the power can be struck off, essentially. Yeah, it's a role that needs to be taken very seriously, and I think with complex conditions, it is better for a professional to take that role. And what I would say is that that's what we would do when we're advising somebody. We would seek out the best professional that knows the person the best, and get them to act in that role, essentially, rather than putting that pressure on, friends, family, somebody else, because it's quite a big thing to be saying, particularly in the health and welfare side of things. Some of the decisions that could be contained in the power are quite significant. So it's not something that we'd advise people take on lightly. But obviously, the law does not insist it has to be somebody that's qualified. So that is the position. And a lot of people making them would just use a friend or neighbour in the situation where capacity is very straightforward. I think that's the difference. In this situation with people with Prader-Willi syndrome, the capacity issues are complex, really complex, and it would be best practice for somebody medically qualified who really does know the person to confirm that they understand the power that they're making, essentially. I don't know how many people with Prader-Willi syndrome are able to make powers of attorney, but obviously the lady earlier, there was a question earlier in the earlier session, and what we would say is that if somebody has the ability to make a power of attorney, that is something that they should try and do, as opposed to the deputyship route with the Court of Protection. The lasting power of attorney is a way of setting out your wishes in a legal document, what you want to do. If somebody can actually do that, that is preferable to a court coming in and making that decision. Although the court does make good decisions, and obviously it appoints deputies, it's preferable to have it done by your own choice if you're able to. So. Yep. Yep. Yeah, yeah. Unfortunately, I think there can be confusion between those two things. It's a very fine difference between being able to manage your finances and being able to know that you're giving a power away to manage your finances. Now, many people will lack capacity for both. They will. But it's where the grey areas are that we've got to be careful to make sure powers of attorney are put in place in those situations where they can be. I've had a situation recently where a client, there was a medical assessment of their capacity to manage her finances, which said she could not manage her finances. But the medical professional had not given any thought to whether she had capacity to make the LPA, which is a separate decision, very, very linked, but separate. When we asked the question, have you considered whether this lady can make the LPA? Yes, she can't manage her finances, but does she know what she's giving away? That's all it is, in sort of layman's terms. It went back to the medical professional. The medical professional undertook a number of sessions with the lady, and the conclusion was that she actually could do the LPA. She could do the attorney. And the risk there was that it was going to go down the court of protection route, and you want to avoid that route if you can. It's the work I do day in, day out is managing professional deputyships, and it's if you can avoid becoming a deputy, it is preferable, really. There are obligations, obviously, on attorneys and on deputies that are very similar, but the regime relating to deputyships is more onerous, essentially. And I'll go on to talk about that a little bit later. But that example that I have, it's what worries me, is that there are professionals out there who are not considering capacity in the right way, and potentially removing somebody's ability to appoint an attorney. And I mean, that was only it was in a finance context, purely that was. But I suspect it happens across the board. And it's sometimes a lack of understanding from medical professionals about capacity, but it's very complex, as we heard earlier. It's so complex, and it's a judgment by one person, essentially, with a lot of a complex legal framework behind it. And so I don't believe the medical professional had any intention to take away this lady's ability to make a power, but they just hadn't considered that there was a difference in the assessment that they were making. And once they realised that, they realised. Now there probably aren't that many people who fall into that category, but it does need to be thought about properly. And I think particularly important with Prader-Willi syndrome, I would say, where it's very complex, where capacity issues are very, very complex. So just to touch on the importance of powers of attorney for parents and carers for themselves, just wanted to mention that quite often the finances of those with disabilities and their parents and carers are intertwined, and if you don't prepare your own affairs for what will happen if something happens to you, then that obviously can have an impact on your child. So often people don't they don't think about this, and then it can become too late, essentially. So things like early onset Alzheimer's and obviously traumatic brain injuries, people quite young now can end up lacking capacity, and then they're not able to make a power of attorney themselves, and then it's court of protection route for them too. So it's as important as having a will, essentially, and most people will tell you that you're best to do them together. So turning on to deputyship and court of protection, obviously, if a person doesn't have capacity to make an LPA, then either a lay person or a professional can apply to the court of protection to be able to make decisions on behalf of that person. So, as I mentioned earlier, the court can make one-off decisions, including declarations and orders, or appoint a deputy where a series of ongoing decisions are required. So in court protection proceedings, the person's often known as P, the protected party. So obviously there's property and affairs decisions and health and welfare, and deputies can be appointed for either of those two things. Again, deputies can be appointed jointly or jointly and severally, and that's the same with attorneys needing to consider which option is the best. Obviously, you can present to the court a plan that you will act jointly with another person if you're going to apply to be a deputy, and overall the court has a decision of what is the most practical situation. The court can either order essentially what's best in the situation. So the law says that the deputyship should be limited in scope and duration, and so this goes back to the idea that this is the courts, stepping in on people's lives. So as far as deputyships are concerned, they should be limited where they can be. So the court will specify where decisions can be made and where they can't, depending on the individual circumstances of the person. And so when you're looking at financial deputyships, there can be restrictions on all sorts of things. So restrictions on buying properties. You can end up in a situation where you need to go back to the court to get extra approval to do things. So that's why I say the attorney side of things is much easier, because you're setting out in a document what can and can't be done. The person has a choice in that. And then obviously the attorney can then use the power once it's registered and everything. Whereas with deputyship, you can be involved in a need to go back and forward to the court to get extra approval for different things. And so that is obviously time consuming and costly as well. The costs of a deputyship are usually taken from the person's funds themselves. So it's not the deputy that pays, it's the person, it's P. Which I think some people think is quite controversial, but that is usually the case. So there are some specific issues that are always excluded from a health and welfare deputy's authority, and so that's where the authority to refuse consent to the carrying out or continuation of life-sustaining treatment for P, and also the power to prohibit another person from having contact with P. So deputyships aren't quite the same in scope as powers of attorney can be. So also with deputyship, there are court fees for the application, £371, and then if the court decides there needs to be a hearing, nearly £500. Obviously, once you're appointed, the deputy is governed by the principles of the MCA, like attorneys are too. The deputy is required to report to the Office of the Public Guardian on an annual basis, keeping records of decisions and financial receipts and documents. So the annual reporting is the thing that people find stressful as well. Having to constantly keep a record and provide a report every year as well about the decisions that you're making and what you've spent. Now that process has in the last few years become bigger than it used to be. There's lots of questions that they're asking. They are now more concerned about how the person is. It's quite rightly, but the reporting requirement has become a bit more onerous than it used to be. It's not just what have you spent. It's not just a financial sort of ins and outs anymore. There's a lot more to it. It's asking, have you looked at benefits? It's asking a lot more. Then when you are appointed, there is an assessment fee by the Office of the Public Guardian, which is £100 at the moment. That's for taking receipt of the order and putting you onto their register, essentially. Then there are annual fees paid to the Office of the Public Guardian for their role in supervising deputies, currently at £320 every year. But there are some exemptions for people on benefits. Obviously, that's a government body. I did used to work there myself before I qualified, and I regularly used to speak to people who were really annoyed that obviously it's a paid service. You don't have any choice. You can't opt out of this role. They are there to make sure deputies are doing the right thing, and 99% of deputies are. But the Office of the Public Guardian does investigate into deputies and can take action to remove them. If actions aren't taken appropriately. Should say as well, the Office of the Public Guardian does have jurisdiction over attorneys as well. So although attorneys do not have to report every year to the Office of the Public Guardian, they do have to keep records. So you have to be keeping records as you go along. If the Office of the Public Guardian investigates into an attorney, they will ask for records. So they could ask you for the last 5 years financial records, and obviously look into what you've been doing, and you can be removed as an attorney if the OPG think that you've done something that you shouldn't do. So obviously it is a role to really consider whether you've got the time and whether you feel able to do it, essentially. The same with a deputy. So there are many more financial deputyships in place than health and welfare deputyships. Basically, in accordance with the legislation, a decision by the court is preferable to an appointment of a deputy in many welfare matters. And what this is about really is that the court does not like to give wide powers out when it doesn't need to. So I think in the financial realm, it feels more able to do that. It's more necessary. Lots more day-to-day things need to happen. With health and welfare, it's keener to make one-off decisions than make a continuing appointment. But there are some examples where it might be required. So in the health and welfare field, where there's a series of linked welfare decisions, and it wouldn't make sense for you to keep going back to court. Sometimes, if there's a history of serious family disputes that could have a detrimental effect on the person's care, then a health and welfare deputy could potentially be appointed to make those decisions, as opposed to having a one-off decision being made. So I did just give a bit of an example at the end. This isn't a real case, but it's similar to what we see quite a lot of. Dan is 18. He's got a learning disability, which means he can't live independently. He lives in a residential care placement, doesn't have any property or savings, and his parents are appointees for his benefits, and his care is funded directly by local authority and the NHS. He can manage small amounts of money and is supported to do that with his care team. He can also make some decisions about care and treatment, but he doesn't have capacity to decide where he lives, and that's come from an assessment by a treating psychologist. Now, everybody involved agree that the placement meets his needs, and he likes it and he wants to stay there. But his parents have always been consulted about finances, about everything. Things have gone well. Now, I know we said we don't hear that often, but that does happen. But what's happened here is that they've got together with other parents, and now they're worried because now he's 18. They're being told that they need greater authority to be consulted in the same way, basically, and they're just worried about being excluded from decisions. And this is the kind of situation that we see quite often. Basically, we would say we need to give consideration as to whether Dan has got capacity to make an LPA now that he's 18, either finances or health and welfare. And the principles of the MCA have got to be considered if he lacks capacity to make any decisions. If he does lack capacity to manage his finances or make an LPA, then the court can appoint a financial deputy. However, in the situation we've got here, it might not be necessary. You've got a benefit appointeeship, that can continue. There aren't really any other finances to manage. Unless an issue arises, there isn't necessarily a need for a deputyship in this situation. If we're talking about where he lives, all the parties can make a best interest decision that he stays there, and you don't necessarily need any additional authority to be consulted about the finances and welfare. And that's if everything's working as it should. The MCA's come into the fore, the professionals are all doing what they should do. There is no need for any additional authority in this kind of situation. But if a dispute did arise, then you could make an application to the Court of Protection. just for a best interest decision about where he lives, and you don't necessarily need to think about a continuing health and welfare deficit. It might not be required. Now, that's quite a simple situation, and often in lots of situations there are more complex facets to it than that. But I wanted to just give that illustration because that is something we see quite regular. People aren't always coming to us with disputes. They are often coming to us with advice from families or sometimes social services saying that they need authority, and it's not true. It's not always true. And so, does anybody have any questions?